Hello. We appreciate the comments you are submitting about the virtual conference, and it is our pleasure to provide you with this opportunity for continuing mediator education every year. At this time, it's our privilege to present our closing plenary speaker, Allison Carrel. Allison Carrel is a clinical associate professor and the assistant director of the Northwestern University Pritzker School of Law's nationally recognized Center on Negotiation and Mediation. She is also the university's first appointed assistant dean of law and technology initiatives. She teaches negotiation, mediation process and advocacy, dispute resolution, and a clinical course in mediation advocacy. Before graduating from law school, Ms. Carrel managed the dependency mediation program for the 8th Judicial Circuit of Florida. She also worked with the Juvenile Mediation Clinic at the University of Florida School of Law, where she helped train and manage law school clinic students in small claims mediation, victim offender mediation, and conflict resolution skills. An active leader, presenter, and trainer in dispute resolution, Ms. Carrel has been examining the process of mediation and how it can benefit underrepresented populations and enhance access to justice. She has diligently explored issues related to the use of emerging technology in the classroom, disruptive technology in dispute resolution, and social justice critiques to confidential dispute resolution processes. In 2014, she was named a Northwestern Digital Learning Fellow, which gave her the opportunity to study the use of wearable technology as a teaching tool in negotiation simulations. Professor Carrel has presented nationally on that study at various conferences. Please welcome Ms. Allison Carrel.
Thank you, Susan, and congratulations on the success of this conference. It's been a joy to attend myself these last few days, and really fun to see all of the comments that people are making about how this is the gold standard. This is how people should be doing it. So congrats to you and your team. Today, I'd like to talk with you all about this idea of reimagining mediation. As the conference comes to a close, I want to turn our attention to what it's going to look like moving forward tomorrow and in the future. I want to do that through the lens of innovation, that some different skills and techniques and approaches that I learned in that role of Assistant Dean of Law and Technology. And I want to do it by revisiting some moments in my career over the last 30 years that sort of caused me pause and made me wonder if this process that I love so much is really living up to its expectations. I think Barry Goldman said something similar in our opening plenary, that he's doing this from a place of love. Me too. And so I want to start by telling you a little bit more about my background as a mediator to give you some context as to how I see my professional identity, well, professional really and personal identity as a mediator. Florida helped me launch my career, and right after undergrad, I had this great opportunity to manage the dependency mediation program at the 8th Judicial Circuit. But it wasn't the first time I had learned about mediation. I had actually taken my first mediation training at the age of 16 in something called it was conflict management in the workplace. I still don't really understand how at age 16 I was invited to attend this, nor why I chose to attend it. I mean, don't 16-year-olds have something better to do on the weekend? But there I was at this training. And when they first introduced this notion of mediation, a process, a structure, just felt something resonate. And the daughter of divorced parents, one who tended to blow up, one who tended to shut down. And I thought this process and clarity about who spoke when would have been really helpful for them. And I thought it would help my dad realize it was time to listen, my mom, it was time to share what she was thinking. And I had hoped that they would have had an opportunity to use a process like this in the midst of their divorce. And as a 16-year-old, there might have been some naivete and idealism at play here, but I really was hoping that we could share this with everybody. This was 1991, I think, and as much as mediation was starting to grow, it still wasn't really well known as much as it is today. And I wanted to spread the news about mediation, and I wanted a career in mediation. But at age 16, I didn't, and in 1991, I didn't know what that would look like. I found myself in Florida and felt very fortunate to be able to participate in the programs, the structure, the system that is the Florida mediation system. It is unparalleled. There's nobody else who does it like Florida. And so let me just say what a joy it is to be back with you all, even if it's virtually. After my time in Florida, I had to really forge my own path. As a very young mediator, I was regularly told, you don't have enough experience. You need to go practice law. You need to go do something else. Mediation isn't a first career, it's a second or a third career. But I didn't want it to be my second or third career. I was already hooked. This is what I wanted to do. And so I just kept trying to forge that pathway. I did go to law school, and I was told I needed to practice right after law school, but I didn't want to. I wanted to return to dispute resolution, being able to apply that ability to think like a lawyer within my process, but I didn't want to spend years practicing before returning to what I loved. For the past 30 years, I've had an opportunity to share that love with others as a training director at a community mediation center, and now as a legal educator at Northwestern. Although I normally am in that position of standing up and being able to share the wonders of mediation with others, I also like just to take the time to have us reflect on those things about mediation that may not necessarily be working the way we think that they are. And that's what I want to do with us today, is really be more reflective, revisit some ideas that have been plaguing our field for decades, and then share with you some projects that I've been working on as ways to transform our field as we move through the 21st century. We're actually 20 years into the 21st century, which I still find fascinating, surprising. I don't believe it. I think we're still entering the 21st century, but here we are. So how can we use 21st century skills and strategies that come from innovation to really reimagine mediation? Let me advance my slide, see if I can do it. There we go. I want to use a metaphor called pandemic as a portal that comes from essayist Arundhati Roy, who published an essay in April in the midst of this COVID, or at the beginning of the COVID pandemic, to help us understand this moment that we're living in. She uses this metaphor of a portal to say, as much as people are longing for a sense of normality, to return to what it is that we knew, doing so sort of refuses to acknowledge the fact that a rupture occurred, that a rupture exists, that we are in this moment where we have a choice to how we want to move forward. And I want to actually quote some of the things that she said, because her language is really strong. She says that this choice of how we're going to move through this portal is one of either choosing to walk through it, dragging the carcasses of our prejudice and dead ideas, or walking through it lightly with little luggage, ready to imagine another world. And that's what I want us to do today, right? Looking at what might be dragging us down and how we can lighten our luggage to move through this portal more lightly. It'd be easy to say that mediation is the way that the legal system is moving through this portal more lightly, right? We're the alternative. We empower, we give voice. And in listening to Judge Kennedy yesterday in the opening plenary, he talked about how, in fact, the ADR community in Florida was that, did that. You all are the ones that adapted. You all are the ones that kept things moving and allowed parties to still experience their mediations and small claims, county, dependency, family, circuit civil, right? You all did that. And if we narrow our lens just a little bit and look within to the mediation community, the mediation field, the mediation profession, what is it that might be dragging us down, weighing us down as we try to move through this portal? I want to talk with you about this idea of pandemic as a portal by talking about our reactions to negotiation, mediation, and the debates that we've had over the years. And Ricky, I'm just noticing that these slides aren't necessarily the right slides, and I don't know if you can quickly upload the other ones. Otherwise, I would totally use these ones. We'll make it work, no problem. But if you are able to do that, I'd appreciate it. So COVID happens, right? And our field says, okay, we've got to adjust. We've got to move. And we do so. As Justice Kennedy said, you guys adapt, you keep things moving, you start using Zoom. We use Zoom and we realize, this notion of online dispute resolution, e-mediation, that to be honest, we had dismissed, we had said was a lesser form of mediation, that we took it and we said, actually, we can do this. And it's not so bad. People are showing up. In fact, people might be more likely to show up. And at least anecdotally, we're not seeing any negative impact on our settlement rates or satisfaction. So here we adapt, right? We are able to move forward and use the technology that we had previously dismissed and now embrace it in order to keep doing what we're doing and doing it really well. There are some people who have noticed this moment and been able to say that this is an opportunity. Thank you, Ricky. That this is an opportunity for us to innovate. And I want to talk about the lens of innovation as a lens through which we can better understand how we're going to move through this portal. So as Susan mentioned, I was the Assistant Dean of Law and Technology at Northwestern, where I was tasked with helping our students understand the changes happening in the law, really being driven by advancing and emerging technology. It wasn't all about technology, but technology certainly was the driving force. And so I want to talk a little bit about the role of technology in the law, not because, listen, I know that not all mediators are attorneys. Thank you very much. I wasn't an attorney mediator when I first started, but we are in a court-connected program. And so we are very much informed by what's happening in the law. A lot of us are attorney mediators, and many of us work with attorneys in our process. So attorneys have a rule about maintaining competence. ABA Model Rule of Professional Conduct 1.1 says that to maintain that competence, we need to keep abreast of changes in the law and its practice. Recently, this rule was amended to include that we have to keep abreast of the benefits and risks associated with relevant technology. So our parties in the room, and for those of us that are attorney mediators, now have this duty to understand the role that technology is playing in what we do. Over 38 states have adopted this rule, and that includes Florida. Actually, Florida's gone further than most other states, in that it's also adopted a requirement that attorneys attend 3 hours of CLE in legal technology related courses. So technology's changing things societally, the legal profession. We have rules that say we need to stay abreast of this. As a legal educator, I tend to work with millennials, folks in the younger generation who are known as digital natives, people that grew up with technology at their fingertips, who we often perceive as being very tech savvy, right? They got their phones in their hands all the time. You can't separate the phone from them. They're very astute at using social media as a way to connect, as a way to communicate, as a way to learn. And yet, when we ask them to use technology in a professional setting, they don't tend to have that same level of skill, that same savviness. And I ask my students to do an assessment using Microsoft Word in the legal setting, and we're both appalled, both the students and me, at their lack of knowledge about the different features that Microsoft Word, right? Just something simple like Microsoft Word has to help them in their use of technology and just drafting memos or briefs. And so I'm always encouraging them to understand how technology can enhance what it is that we do. Technologists, though, tell us it's not just the technology, right? And it's not about the technology. It's really about innovation. It is about the use of innovation and design thinking to look at problems and reimagine them. People first. What are people's experiencing? What's working? What's not working for them? Designers and innovators are taught to empathize, just like us. They're taught to understand, learn, be curious about the user experience. Second, what are the processes at play that are not really working, and how could we improve them? And then third, technology. Can technology be the thing that will help drive us forward? So it's a people first understanding of problem solving, just like in mediation. There's a lot of similarities. But I teach students about technology because if technology can be the thing that brings that change to help the people have the experience that they need, then they need to have some awareness and competence in technology to be able to meet that need. I teach my students about design thinking as lawyers because of the changes that we're seeing in the legal profession, but I also teach it to my mediation students as a way to expand their skill set, a way to understand a broader set of skills in the mediation setting. And some of you might have, I learned that April Walker and Lawrence Colley from Upchurch Watson held a CLE last year, webinar 2019, doing this, or taking these notions of design thinking and applying these same mindsets and skills to the mediation setting. Recognizing that in innovation, collaboration is very important. So using that mindset to understand and create a foundation for a joint session. Innovators ideate. They try to generate as many different ideas as possible as part of their problem solving process. Not what we do, right? We're trying to get parties to generate options. So using some of the ideating strategies that innovators and design thinkers use, bringing that to the mediation process. And then they prototype and test, right? Just like we reality test and help our parties look at their options and say which one of these is going to be best for us. So April Walker and Lawrence Colley in this webinar really helped mediators see how you can apply design thinking to the mediation process. And I try to do something similar with my mediation students after I've indoctrinated them with the wonders of mediation and help them see what we all are so passionate about. I then try to expand their skill set by introducing this larger notion of innovation and design thinking. And then I have them do almost like a meta mediation. I have them look at the field, start understanding where some of those challenges and barriers are to us being as effective as we want to be, and use innovation and design thinking as a way to reimagine mediation. So I just want to share with you an example of some projects that students have done so that you can see how this innovation lens can really help us completely reimagine mediation. So I share with them a study that was conducted in, 2017 by Professor Donna Shasowski that studied litigants' understanding and awareness of the availability of different process options at the court, and then their perceptions of the court based on those process options. And what she found is that over 76% of the litigants didn't even know a mediation program existed. As somebody who loves mediation and has dedicated her entire career to it, this is really disheartening. And so I share it with my students to say, all right, you drink the Kool-Aid, you've been bitten by this bug too. What are we going to do to fix this problem? Now, I want to admit, in this study, litigants from Florida were not interviewed or surveyed. So this does not include Florida as part of their data set. However, the courts that they did interview litigants from were very similar to Florida in that the courts all had an option of mediation. Many of them were opt-out, where mediation was the default choice. And yet still, over 76% of people they surveyed didn't know that the mediation program existed. So I share this with the students. I have them read the study, and then I say, okay, use the mediation mindset, use that design thinking mindset, look at the problem. What's really going on? What needs aren't being met? What process is in place that is creating these barriers? And then ideate, brainstorm, come up with some options that might creatively solve this problem. So here's one example of something the student did. This is an online automated expert system that a student designed and coded using something called Q&A markup. The student's not a coder, doesn't know how to code, but could use this platform to create really just a decision tree for a party to answer as they are considering what their options are. The expert system prompts the user with a question. It asks them to answer yes or no, and based on the user's response, it uses some if-then statements to decide what the follow-up question will be. ultimately walking them through an entire decision tree analysis about what options exist and which one is most likely best for them. Now, this example comes from a community mediation program, and so it really is all about, are they even eligible, or is their case appropriate for mediation, which is different than maybe in a court program. But as you can see, just based on the answer somebody gets, it's prompting them with another question. This student hypothesized that if all litigants were asked to do some type of similar decision tree using this automated expert system, we could guarantee that they've at least considered all their options and thus know what their options are. Another student, though, created something. This is almost like a Tinder-like app for mediation. Okay, so let me just explain this for a second. So what she said is, all right, yeah, 76% of the litigants don't know mediation exists, but in Illinois, at least, even for the 24 that do know about mediation, they're not utilizing it the way that they could. We have a real problem with the scheduling and the structure of how parties get to mediation. And so I want to make that easier for people. So she creates this Tinder-like app where you get to scroll through mediators, swiping left, swiping right, to decide which mediator is the best match for your case. These are just two examples that I thought would demonstrate just how creative we can be if we use the lens of innovation and design thinking to really think outside the box of how we are engaging the public with mediation and how the process is being experienced by parties and how we are serving the public. So now what I'd like to do is share with you some more specific projects that I'm working on, trying to reflect this same innovative lens in understanding our process. Reflecting on some moments in my career that sort of caused me pause and made me say, I love mediation, but man, we are not stepping up. This is not as great as I think it is. So how can I use innovation, design thinking, and really the mediator's mindset to try and reimagine this with a better solution? So let me start with the concept of BATNA. We all know what BATNA stands for, Best Alternative to Negotiated Agreement. And we all know that BATNA can be a very powerful tool in impasse breaking. Now, working across different programs across the country, I can tell you that we use BATNA to different extents. So some programs only use BATNA when parties hit an impasse. Other programs require their mediators to ask their parties to do a BATNA analysis, no matter the direction of the mediation, whether or not they're moving towards settlement or not. The real debate becomes around who should be doing the BATNA, right? So now I'm just talking about our age-old debate about facilitative or evaluative mediation, a debate that when Professor Riskin first launched his mediation approach grid, didn't intend for it to be seen as such a dichotomy, an either or, but certainly has been in practice. And although we know that facilitative mediators can incorporate evaluative concepts by simply asking questions and allowing the parties to do the answers, we still identify and put ourselves in these camps of facilitated or evaluative. And I will be honest, I am squarely in that facilitative camp. My initial training, both at age 16 and then of course in Florida, was in facilitative mediation, and those roots are very deep. And I recognize that some parties really value having an external evaluation about their BATNA and what's going to happen if they go to court. I also recognize that there's a situation where as a facilitative mediator, when I'm working with a party who doesn't have experience in court, asking them what they think is going to happen, and they're like, I don't know. I have some tools to deal with that as a facilitative mediator, so I'm not trying to undermine the facilitative process at all. But it is worrisome when we think about the decisions that people are making in mediation when they don't have this background knowledge. Professor Trina Grillo, back in 1990, published an article called Mediation Alternatives, Process Dangers for Women, where she pointed out some concerns that she has. Now, first of all, she says she's an attorney mediator, and she actually really loves sitting in that seat as the mediator. So she prefers to do. And she recognizes the party satisfaction that people report by being in mediation. And she worries about the unintended consequences that these processes can have on individuals who might have otherwise been marginalized. So she talks about a woman's experience in a family mediation in this microsocial setting that seems to imply there's a certain way to behave, a certain way to approach settlement and speak. And that microsocial setting might be sending cues to a woman that she needs to prioritize the relationship over financial security. Or it might be less subtle and actually have a mediator telling her, wow, assuming that relationship is more important than her financial security, you should settle. This is going to be better for you. If you go to court, it is going to rip the family apart. Those things might be true for a party, but we can't assume that they are true. And this idea that mediation is a way for us to settle disputes and that it can be better can send some subtle cues that force someone or at least make them feel pulled to settle. Just in the session before this, there was a speaker whose name I'm forgetting. I apologize, but he was doing a session on Howard Marcy. Sorry, he did the session on the mathematics of zero-sum mediation, and he talked about a concept called agreement bias. It just says the longer we are in the midst of a negotiation, the more we feel pulled to trying to reach a settlement. And so how can that impact a party who may be in a situation where they are balancing and prioritizing these two pieces of, let's say, relationship and financial security? And so how do we as facilitative mediators and evaluative mediators help parties make those informed decisions that we know they have a right to do in a way that is most effective? So last year I published an article with Professor Noam Ebner, who I think was one of your plenary speakers last year, that explored the use of technology in a mediation, whether it was offline or online, as a way to address some of these problems. We wanted to look at existing technology that people are using but aren't leveraging in mediation to see if we can enhance our process, the party's experience, and address some of these concerns. So we pointed to data analytics as a way to address this piece about the Batten analysis and the camps of facilitative or evaluative mediation. So data analytics is really just the use of large amounts of data to identify trends and insights about what's happening. And in the court setting, we call it litigation analytics, where we can study things about judicial behavior and court structure to help us understand what is happening in the court. So in a mediation, someone can use these litigation analytics as a way to do the Batten analysis. They can actually look at the average length of time it takes for a case to go to mediation, not someone's perception of what it's going to be or someone's hunch, but how much time has it actually been. It can look at judicial behaviors to the likelihood or the number of times that a judge has granted summary judgment. And so we move the Batten analysis from relying on the individual's experience, which can range from an individual who's had zero experience to an attorney who has had some experience to a retired judge who has 40 years of experience on the bench, and broaden it to be every case that has been before this judge in this jurisdiction. We can understand and see the historical behaviors in nature. Now, let's put this back into this facilitative evaluative camp. How can this change and transform our understanding of what has been applied as a dichotomy? So I'm a facilitative mediator. A party says to me, I really wish I knew what would happen in court, but I've never been there. I have no idea. As a facilitative mediator, I can't give you that evaluation. How are we going to help you get that? As a facilitative mediator that has these litigation analytics available, I might be able to say to the party, would you like to access this information? So I'm still being facilitative. I'm being responsive to her interests. And then she decides if she wants this. So she says, yes, I do want to. Okay, we run the analytics. We give her this report. It's data for the facilitative mediator now to ask some further questions about. It's not dictating what the individual should do, what the party should do, but it certainly gives us a very thorough look at what the historical behaviors have been of that court. So as a facilitative mediator that's using litigation analytics, I'm ensuring the parties are getting that evaluation, that very thorough, maybe even more accurate evaluation, but I'm not doing it myself. And so now, yes, I'm a facilitative mediator, but because I'm the one that is giving access to this evaluation, maybe I'm a facilitative evaluative mediator. No longer an either or, but an and. Let's look at another tenet of mediation, and that's confidentiality. Yesterday, Sharon Press and Greg Firestone introduced this notion of providentiality. And I'm not talking about changing our terminology or helping people understand the notion of confidentiality. I'm saying, this project is about how can we protect confidentiality and deal with some larger societal issues that stem from the abuse of confidentiality in private settlement. And I'm going to do that by talking about this guy. In 2017, Ronan Farrow breaks the story that Harvey Weinstein had been engaging in regular acts, sexual harassment, assault, and even rape. And yet these multiple acts had been swept under the rug through the use of private settlement and the abuse of NDAs. In reaction to this abuse of NDAs, and in hopes of protecting potential future victims of these acts, many states and agencies decided to remove the right that somebody has to a confidential settlement and say that in any instance of a sexual harassment claim, the settlement must be public. We are no longer going to allow these NDAs. So they passed laws that make them unenforceable or prohibit them outright. Great. Let's protect these women from this type of heinous behavior, 100%. And as mediators, we know the value of confidentiality, not only for the accused, but for the accuser as well. Both sides of the table may have an interest in this confidentiality. And so by reacting to the Harvey Weinstein situation, the intent is great, let's protect people, but it removes an entire option. So historically, Owen Fisk talks about this in 1984 by calling it against settlement. So he puts this in terms of we have either private or public settlement. And he argues a very similar argument to what's happening in reaction to Harvey Weinstein to say, in order to protect and inform the larger public, the interest in doing so outweighs any benefit of a private individual settlement. Now, this was a debate. His article came out in 84. We debated this for many years. And with the proliferation of mediation, I think it's easy to say we won, the mediators. We know there's a value in private settlement. And unless a plaintiff chooses the public route and to go to court, they should have the right to settle and to keep this information outside of the public eye. But in light of these revelations and this shift from private or public to an only public option, all of a sudden we got to think, wait a second, there's got to be a better way. And as a mediator, when I first started hearing about the Harvey Weinstein cases and reading Ronan Farrow's articles, I thought, were we maybe on the wrong side of history? By promoting this private settlement, had we helped create this situation? And that really troubled me. As somebody, again, who loves what we do and knows that there's value, it still is really problematic and worrisome to see what was happening. So, like with the facilitative or evaluative debate, where I'm trying to create an and, I wanted to think about settlement as not just private or public, or as many states have turned it into just public. Is there a way for us to have a private and public approach? So I recently started working with a computer science professor to develop a system that allows parties to still choose a private settlement, but if there is a subsequent allegation or claim against that individual, that private settlement then becomes public. So it's a private then public system. There's the motivation behind this was because of a program on college campuses called Project Callisto that allows individuals who have suffered a sexual assault to report it, but report it confidentially, unless and until there's a subsequent allegation against the same individual. So it allows someone a reporting mechanism without that fear that a lot of sexual assault victims experience, that I'm not going to be believed, or if I go public with this, I'm going to be ridiculed. And so Project Callisto says, report it. We'll keep it confidential unless and until there's that subsequent allegation. Professor Ian Ayers applies this to the settlement space and uses the example in employment discrimination of something he's calling an information escrow, the use of a trusted third party to collect the settlement data and then review it to look for those matches, and where there's a match, now decide how we're going to make this information public. So in employment discrimination, maybe it's the EEOC that's collecting this information. They identify that there's a match, and then they decide, do we let the claimant know? Do we tell the respondent? Or do we launch our own investigation entirely? With computer science professor Zhao Wang, we're trying to develop a similar system that uses a cybersecurity platform called multi-party computation. You don't really even need to know the name. I'm just going to call it MPC, but uses this cybersecurity platform MPC to encrypt the data, keeping it entirely 100% encrypted and private. Ownership retained by the settlement parties, not given to some third party, as a way to create this private, then public situation. I asked Professor Wang to help me explain how MPC works and why it's different than this information escrow idea that Ian Ayres has come up with. And so these are some of his slides. So I just want to walk through it because I think it's a really simplistic way of understanding MPC and this encryption. So the way that these computer scientists describe MPC is through something called the Yao's millionaires problem. And Professor Wang and his JD PhD student, Peter Chain, have changed this to Yao's billionaires problem and using Donald Trump and Elon Musk. So here's the idea. You have two billionaires. Both of them want to know which one of them's got more money. They can, to find that out, just tell each other, I make this much. Oh, I make this much. Okay, now we know Trump's got more money. To do this comparison, though, and to complete the computation, they have to reveal to each other what their wealth is. But what if they don't want to reveal what their wealth is? They want to keep that confidential. They just want to know who's got more. Well, they could use a trusted third party, right? This is the Ian Ayres example. They could ask Pope Francis, we're going to tell you what our wealth is, not divulging it to each other, but to you, our trusted third party. You do the computation and you tell us who has more. Output, Musk has more money. Not telling us how much, but just who's got more. The problem is we can't always identify a mutually trusted third party. We think there may be some liability in holding some of these inputs, especially inputs that we're trying to maintain confidentiality of. And anytime there's an active divulging that information, there's a chance to be hacked or breached. So the computer scientists have this cybersecurity platform called MPC, where the parties retain the ownership and control of their data. They encrypt it. They put it into this black box. It is not a human. It is not an organization. It is not an agency. The platform cannot divulge the information because it is encrypted, but it can compute the information to put an output that can be public. In this situation, the input that's encrypted is a specific amount of wealth that each individual has. The output is public about who has more money. And so in the, okay. Yeah, there's a whole technical side to it. I'm not a technologist. I just like to call myself tech curious. So all this stuff is happening. That's why we have the computer scientists and why we have to work with them. But the idea is that we can protect the confidentiality of these cases fully, 100% using this cyber secure platform to allow us to have that private settlement option while still protecting future potential victims of an assault by identifying repeat offenders. So the notion here is that instead of it being private or public or just public, we can have a private then public option so that both sides are met. You can see how the mediator's mindset is here, right? Trying to move from an either or to an and, a mutually satisfactory option. That's the goal. Let me go to yet another issue within our field. The issue is not neutrality. I don't think there's any debate about whether or not we should be neutral, but what that actually looks like can sometimes be up for debate. So in 1981, Professor Lawrence Susskind argues that the dichotomy between private and public is really the mediator's responsibility to manage. He says that mediators really need to ensure that outcomes of mediation lead to socially desirable outcomes and precedents. So he wants to protect those people that aren't at the mediation from some unintended harm that takes place because there's a private settlement. This is somewhat similar to the Harvey Weinstein case, and I'll get into that in a second, but let me give you a different example that I think makes the point a little more strongly. And it comes from a moment that I had in 2000 when I was touring law schools, deciding where I wanted to go. I was at a law school that happened to have a mediation presentation taking place, sitting in the audience and soaking it up. So excited to see people talking about the benefits of mediation. I can't actually tell you the very specifics of the talk because in the midst of it, this audience member stands up, slams his hand down on the table, which both of those things I was like, that's not very mediator-like. Slams his hand down on the table and yells, "But what about Brown v. Board of Education?" The seminal school desegregation case that says all students have the right to go to a school of their choice or to a equal opportunity to attend a good school. And what he says is if that case had been mediated, then the children in this picture, who are Vicki and Donald Henderson, Linda Brown, James Emanuel, Nancy Todd, and Catherine Carper, they might have been able to go to the school of their choice. But the others in the case, the national precedent that was set would not have occurred. And so this concern about private settlement taking away the rights assertion and precedent that protects the larger public is one that's been debated for a long time. So when we return to this Harvey Weinstein situation, we can see how that might play out. Let me go back a little bit. We can see how that might play out where because these cases have been swept under the rug, the larger national sort of narrative around sexual harassment isn't accurate. Women are afraid to talk about the experiences that they have because they won't be believed because people don't know the extent to which it is happening, okay? And so we need a system that still informs the larger public without taking away that right of private settlement. So back to the MPC example, if we can allow parties to have a private settlement, put that information in this black box encrypted through the use of MPC, but anonymize it to be able to present statistical information about these types of claims, might we create a private and public settlement? So let me give some examples that will be very clear and timely. The first map on the left is a COVID-19 outbreak map, right? In public health, we do this all the time. We have individual health records that are not divulged, but in their aggregate, we are able to identify hotspots of illness. The map on the right is a similar type of hotspot, but this is where individuals who experience the sexual harassment self-report to an app, and it creates this hotspot map of where these situations are occurring the most. The problem with the current systems of trying to understand and identify the extent to which sexual harassment is happening is that it's relying on self-reporting and it is one-sided. So Professor Deborah Turkheimer calls this the double whisper secret network, whisper network, where she says that we're getting this information and people are finding ways to spread the news about the sexual harassment, but because it is one-sided and only coming from the accuser's side, the argument is that, wait a second, the accused hasn't had a chance to defend themselves. How do we know that this is accurate? And so the difference with an MPC program is that we're focusing on settlement. We're having the two parties decide that they want to have the settlement. They can have an NDA, but they have to put that information into this black box of the MPC to allow that information to be anonymized and aggregated so we have some statistical information about the extent to which sexual harassment is happening. This removes the debate about whose responsibility it is to ensure that the public is informed about these social harms when we have private settlement, because the system in and of itself is the one that's going to be doing the informing. It's not the mediator, right? They don't have to make that decision. It's part of the structure. So somebody has asked if this type of MPC black box technology is actually available. It is available. The idea of MPC technology has been around for a while. It is still in development as to its processing power to do these types of computations quickly. And that's what Professor Zhao Wang is working on. His unique piece is to how to do this quickly, to make it actually a viable option, and then two, applying it to these different types of options and settings. So we're talking about technology as a as a means. It's not technology first. It's not about the technology. It's about a problem and using technology as a means to help us reimagine mediation and move into or transition or walk through what is the 21st century, right? But this does require that we sort of expand our understanding and comfort with technology. We already talked a little bit about how we've done this with Zoom and how Judge Kennedy recognized your all's ability to adapt and adapt quickly. But we still have a sense about technology that says it's not appropriate in a mediation, except as now this communication intermediary. It's a distraction. We have ethics advisory committee ethics opinions that describe worries that mediators have about people abusing the use of technology to break and breach confidentiality, using technology in a way that's going to intimidate others because they're typing notes, collecting information, maybe using it against them later to incriminate them. Of course, the advisory committee has said party self-determination, number one, mediators cannot dictate whether or not parties can use technology, but we all know it can be distracting and they're still worrisome. In the legal education classroom, I deal with this all the time because students have, well, let me just put up this picture. Students have these laptops in front of them and all they're doing is staring at them. And half the time, what they're looking at is an internet, they're surfing the internet, they're shopping, they're on social media. They're not paying attention to what the lecturer is actually saying. And so in higher ed, we're trying to get rid of laptops in the classroom. Of course, this is pre-COVID. And then there's research sort of back up that if you use a laptop to take notes, you're actually going to be less prepared for an exam than if you had taken those notes by hand, because writing notes by hand forces your brain to process the information and then distill it as you write it, as opposed to just transcribing it. And so as a legal educator, I'm looking at instructional technology to say, it's not the technology that's the problem, it's how we're using the technology. So you could argue, right, a laptop's not just a typewriter. It's not just a conduit to the internet. It is something that we should be harnessing to engage our students and in mediation to engage our parties. So if we change our understanding of technology as one solely as a communication intermediary in the ODR context, or two, as a physical barrier between our parties, so the picture on the left, something that's physically getting in the way of them connecting, and switch our understanding of technology to the picture on the right, something that brings us together and allows us to collaborate. Now we're using technology effectively. Now we can see how technology might be able to enhance what's happening in mediation. So that's a lot of the work that Professor Noam Ebner and I are doing. That is why and how I am trying to connect with the computer science professor, Zhao Wang, to understand how technology can be a means to really reimagine what's happening in our mediations. That slide. Before I wrap up, though, I want to take just a couple more minutes to return to this metaphor of pandemic as portal and some of the language that Arundhati Roy used. She said, again, that we have this choice to walk through this portal, dragging the carcasses of prejudice or dead ideas, or we can walk through it lightly with little luggage. I've talked a little bit about the role of these carcasses of prejudice and dead ideas within our field to understand how we can walk through the portal, hopefully a little more lightly. But I want to take just a moment to go a little bit more deeply in the carcasses of prejudice component of what she says, and recognize that we're really in the midst of a second pandemic that stems from the deep-seated racism in our country. So deep-seated that I understand it can be hard to see. In the mediation space, though, we see it very clearly when we take a look at the diversity of our pool of neutrals. Lawrence Gordon, who's a Florida mediator, hope he's with us, recently published on the Palm Beach County Bar Association website a comparison of the representation of African Americans in the general Florida population versus in the mediator pools, and identified that 16% of Florida's population are African American, but only 3.8% of Florida mediators are people of color. He did the math, that equals 122 mediators, right? This does not match up. In 2018, Jay-Z shines a huge spotlight on this when he sues AAA, saying that the roster they gave him of arbitrators for his large and complex case included only 3 African Americans out of a total of 200. He's like, that's not going to work, right? We've known that this is an issue for a long time, and we've seen initiatives to try to change this. 2018, the ABA House of Delegates adopts Resolution 105, encouraging providers to expand their rosters with diverse neutrals and encourage parties to select diverse neutrals. In the fall of 2019, ABA's Mediation Week is dedicated to the theme of the importance of using diverse neutrals, right? We're trying to address this problem that we know exists, but to what end? If we still have this issue, what's really going on? So the Center for Effective Dispute Resolution published a report last year that said it's not just about selecting diverse neutrals. Yes. And we have an entire pipeline issue of how we are welcoming and encouraging diverse neutrals to join. And so while most initiatives focus on points 4 and 5 of their 5 points of barriers to diversity in commercial mediation, I want to focus on the first 2, which have to do with the notion of becoming a mediator in the first place and then the experience in a training. Actually, because of time, I'm going to focus just on the second one. So they ask us to think about, I'm going to read some language here from their report. They say that the strongest potential barrier to having more diverse neutrals has to do with the culture of mediation courses and the associated characteristics that course plays on what is a good mediator. They point to what happens in our mediation trainings. I love our mediation trainings, right? This is where you get to stand up and see the light bulb turn on and the paradigm shift happen. But what happens when we're actually in simulation and giving someone feedback? They point to a 2014 study that demonstrated how unconscious implicit bias is at play when critiquing someone's performance when we look at race. And this is a study that said, this is a study that took a group of senior attorneys and said, here's a memo. We want you to review and edit this memo and give the summer associate some feedback. Half of the attorneys were told that the student, a summer associate who had written the memo were Black, and half of the senior attorneys were told that the memo was written by a white candidate. Everything else about the memo was exactly the same. The wording, the format, the memo, the exact same piece of paper. The name associated with the memo, the exact same. The resume associated with the name of who wrote this memo, the exact same. And yet when the edits came back, the senior attorneys who had reviewed the Black memo identified twice as many errors than the senior attorneys who reviewed the white memo. Same memo, right? This is implicit bias at play. We put that into the mediation setting, we can say, okay, when we are critiquing someone's performance as they're trying to learn this, for many of us, major paradigm shift in how we are approaching conflict, what are we doing that might have implicit bias at play, the feedback that we're giving? There's a lot here. And we could spend a whole nother half hour talking about this second pandemic and the carcasses of prejudice and dead ideas that we are bringing with us. But instead, what I want to do is just take us to the moment that we're in right this moment, right now. Your conference is ending in less than 5 minutes. You've had 2 days of incredible programming about all things mediation, a field that we are all dedicated to and love. And I share that dedication and love. But when we look at this portal that's before us, we have to consider the choices that we have. We have a choice to drag these things with us, hanging on to that which we took as truths, debates that will never be resolved, or we can reimagine with a lens of innovation to say there's many other ways to do this. Sometimes it's going to require technology. Sometimes it's going to require some additional education and reflection. So I'm not dictating what path we take when we cross that portal, but imploring us that as we cross that portal, we do so with eyes wide open and recognizing the weight that we might be bringing with us as we do so. I know we don't have time for questions and answers today, but I am putting up here my email address as well as my Twitter handle. If you would like to reach out, I would love to talk with you all. As I mentioned at the beginning, it is truly a joy to be back with the Florida community given all that you all have done and are doing for our mediation field. So thank you so much for this time. Susan, thank you for the opportunity, and congratulations, y'all. Success, gold standard of a conference. You did it. Thank you.
Thank you, Allison, for giving us these ideas on reimagining mediation in the future and being creative and helping us just see that we're in that portal. This virtual conference maybe demonstrates that we can move through the portal, and maybe we can do it without too much pain, and do it creatively. So we really appreciate your message and your ideas about how to think about things in the future. It has certainly been our pleasure at the DRC to sponsor this virtual conference, and we encourage you to complete the post-conference survey that you will receive in an email in the next few days so that we can gather your thoughts and impressions. And we hope to see you again next year at the 29th Annual DRC Conference. Save the date, August 12th through 14th, 2021. At this time, we are planning on having an in-person conference at the Rosen Center Hotel in Orlando, but we are considering providing that conference both in person and electronically due to many of your comments and our experience. So we just want to thank you so much for ethically facilitating the peaceful resolution of disputes in Florida. Keep up the good work. Thank you.